Good evening, everyone. We are requested to make the series from the beginning. A very good evening. Honorable Mr. Justice Gawai, Honorable Mr. Justice Vikram Nath, a very warm welcome, sir. I'll request Justice Vikram Nath to please take the seat. Justice Rebello, Mr. Santosh Paul, and Ms. Norma Alvarez. It's a pleasure to have all of you over here in this evening, sir. We begin this beautiful evening by extending a floral welcome to all our distinguished guests, each of whom brings decades of wisdom, service, and scholarship to the legal world. Honorable Justice and Honorable Chief Justice of India, Justice B.R. Gawai, a jurist admired for his clarity, warmth, and deep commitment to constitutional values. I request Justice Rebello to please present him a bouquet. Honorable Justice Vikram Nath, known for his balanced judicial approach and calm authority, I request Ms. Triveni Potikar to present a bouquet to Justice Vikram Nath. Ms. Norma Alvarez, Senior Advocate, distinguished for her legal activism and environmental work. I request Mr. Mayank Naik to present a bouquet to Ms. Norma Alvarez, Senior. Mr. Santosh Paul, Senior Advocate, whose scholarship and advocacy have shaped contemporary legal discourse. I request Mr. Naveen Sharma to present a bouquet to Mr. Santosh Paul. Thank you so much. It's wonderful to have all of you over here with us. I request Aditi to present a bouquet to Justice Rebello, the man of the evening. To set the tone for the evening, we now have amongst us Ms. Delphine Rebello with the timeless words of Gurudev Rabindranath Tagore, Where the Mind is Without Fear, a perfect reminder of the spirit behind the book we celebrate today.
My God. Should I start? Yeah, I can see. Yeah. Yeah. Okay. Where the mind is without fear, Rabindranath Tagore. Where the mind is without fear and the head is held high. Where knowledge is free. Where the world has not been broken up into fragments by narrow domestic walls. Where words come out from the depth of truth, where tireless striving stretches its arms towards perfection, where the clear stream of reason has not lost its way into the dreary desert sand of dead habit. Where the mind is led forward by thee to ever widening thought and action, into that haven of freedom. My Father, let my country awake. Oh, huh? Okay. I think it was not heard half the time. No?
It was very nice. Thank you so much, ma'am. And now, to formally welcome everyone, may I invite Mr. Akash Rebello, someone who's worked tirelessly behind the scenes and whose presence is central to the celebration today.
Hi, good evening, everyone. Welcome all this evening to the book launch of my dad's book, Our Rights Essays on Law, Justice, and the Constitution. We have the pleasure to have with us today Chief Justice of India, Justice Gavai, Justice Vikram Nath, other esteemed judges of the Supreme Court, the Chief Justice of the Delhi High Court, who was formerly our Chief Justice in Bombay, the chairpersons of various tribunals, and various former Supreme Court judges, all of whom were my father's colleagues in both Bombay and Allahabad, various other senior advocates and other dignitaries. Thank you all for coming, and all the other friends and colleagues from Delhi, Bombay, and Goa who've made it all the way here. This book and the essays therein, at least to my mind, are an evidence and approach to constitutional law from one of the first generations born into an independent India. My father was perhaps 2 years late to be Midnight's child, but fits exactly into that generation that Rushdie sought to characterize in his book. He and his cohort and his generation were enthused by the prospect of nation building and approached human rights with a zest that we, the incoming generation, have a lot to learn from. They have all led extraordinary lives. They were born around independence. Their political awakening was in and around the emergency. And their legal development was at a time when the Supreme Court led judicial innovation in protecting human rights. For my father, this path led from activism as a lawyer to public office. First to the assembly in Goa as part of the JP movement, then to the Bombay High Court, and finally to Allahabad. It therefore brings us as a family great joy to welcome all of you who have been his friends and colleagues over the years to this book launch. In many ways, most of you have been collaborators in this book, in helping shape the views that form the basis of the essays contained in this book. They have been written over a long time period as a lawyer in the 70s, as a member of the assembly, and then as a judge. So from the judges whom he has shared a bench with, to the lawyers with whom he argued against and who argued before him, and to some of those who go back all the way to college and school, a big welcome to all of you. Thank you.
Those words sounded truly like coming from a son's heart. Before we listen to the author speak about his work and the book itself, it is my privilege to introduce distinguished jurist and a truly multifaceted leader, Honorable Dr. Justice Ferdinand I. Rebello. A big round of applause, ladies and gentlemen. Akash has already covered most of the content that I had prepared, but please bear with me because the celebrations in the career of Justice Rebello are just countless. Justice Rebello has been the former Chief Justice of the High Court of Allahabad, a position he assumed after an exemplary tenure as a judge of the Bombay High Court. His journey to the bench is as impressive as his service on it. Before his elevation, he had already made his mark as the president of the Goa High Court Bar Association, an elected member of the Goa Legislative Assembly, and a lecturer at the Salgaonkar Law College. His engagement with public life began really early, spanning legal education, legislative service, and social movements. He was also a part of the Bombay High Court delegation that studied mediation systems in the United States, reflecting his early interest in modernizing dispute resolution. He was appointed as the judge of the Bombay High Court in April 1996 and was elevated as the Chief Justice of the Allahabad High Court in 2010. On the bench, he earned the admiration of both the bar and the bench for his efficiency, clarity, and outstanding case disposal rate. His judgments and leadership have left a deep and lasting imprint on the legal community. Even after retiring from the judiciary, Justice Rebello has remained an active and highly sought-after legal mind. He continues his work as a senior advocate, an arbitrator, and a legal consultant. He has served on the advisory committee of the Mumbai Center for International Arbitration and on the advisory council of the University of Mumbai Law Academy. With over 140 domestic and international arbitration matters to his credit, he has appeared as an arbitrator and expert witness in multiple global fora, a testament to his expertise and international respect. But beyond the positions he has held, Justice Rebello is cherished for the values he embodies, a profound scholar, a dignified statesman, and an inspiring leader. His unwavering commitment to human rights, especially the rights of women, children, farmers, and marginalized groups, has been pioneering. Many in the legal fraternity recall how his words, both within and outside courtrooms, carried moral clarity and encouragement. His leadership has fostered a culture of motivation, excellence, and integrity across generations of lawyers. The book before us today reflects the breadth of his intellectual contributions. In Our Rights, Justice Rebello brings together the reflections on constitutional values, legal anomalies, adoption law, reservation policy, caste discrimination, criminal justice, human rights literacy, and global legal landscape. His work explores foundational principles rule of law, judicial decision making, and the enduring necessity for law to remain aligned with justice. It is an honor for all of us to have him this evening. I'd request Justice Rebello to please say a few words about his work. Ladies and gentlemen, please welcome him with a round of applause.
Good evening, everybody, and a special good evening to our friends on the dais, Chief Justice Gawai, Chief Justice Vikram Nath, Norma, my colleague at the Goa Bar, and Santosh Paul, who have become a friend from Delhi. The Constitution, in its preambular concepts, reflects the hope and aspirations of our people as we have crystallized together as a nation bound by the rule of law. The basic structure doctrine articulated as a part of our constitutional philosophy, as reflected in M. Nagaraj, ensures certain basic rights are inviolable and free from partisan political considerations, thereby keeping alive the constitutional philosophy propounded by our founding fathers and as reflected in the written constitution. My life has been a journey from the Mandavi in Goa to the Kali in Karnataka, the Godavari in Maharashtra, and the Ganga flowing to Uttar Pradesh. The civilizational aspects of the people along the banks of these rivers have shaped my life and thoughts. The journey has been a journey of an activist and a professional. A young activist in college while studying for my law degree, an MLA post emergency, a young lawyer espousing the rights of the working class, the marginalized, and those from, and there from a designated senior advocate, taking an oath to uphold and defend the Constitution, and now continuing that journey in pursuit of justice. The 27 articles in this book, grouped under 7 heads, are all concerned with legal subjects, except an article on Mahatma Gandhi, which reflect my journey as an individual who has lived through the experiences, including being incarcerated in the Aguada jail for defying prohibitory orders, espousing the cause of livelihood of traditional fishermen of Goa. The article on Mahatma Gandhi is to reflect on the man who led us to our independence, ingrained morality in public life. Independence gave rise the right to us to adopt a constitution as guided by Dr. Babasaheb Ambedkar in the Constituent Assembly. As a young lawyer in Goa, I was representing orphan children who had been asked to leave the orphanages without being rehabilitated or trained for a gainful occupation. The first bench, after lengthy hearing, dismissed the petition by simply observing, "Petition dismissed, what beautiful poetry." The next bench, which was moved by a different set of orphans, more receptive, granted reliefs. It was in this petition that I learned my first lesson as to what justice is and ought not to be. It is not your rights, but which bench hears the matter. And this perhaps is reflected every day in our courts. This is not a criticism, but a thought for consideration of the functioning of our judicial process. A judge, it is oft repeated, should not comment on his own judgment. Let others comment. This judgment on which I have reflected was the raison d'etre of my judicial career. I articulate the judge's position thus: the fight against injustice must be inherent in you. It cannot be conferred or imposed by a mere occupation of a judicial chair. Justice does not flow from the chair, but from the person occupying it. The chair reflects authority. The weak should not occupy it, nor the submissive. The constitutional structure will be damaged beyond repair if constitutional functionaries fail to express their views. Expressing views which may not be palatable to some is not dissent, but upholding of constitutional values. These are not the straight thoughts or rambling thoughts. These views are born out of experience, a reflection of the present and the past. The very first article in this book are my reflections on the adoption judgment. This article reflects the difficulties faced by a judge in granting relief after recognizing a fundamental right in an individual. The faces of two young children, full of life, having given in guardianship, made me reflect on the future of these children. Our laws, except for Hindus, including Sikhs, Buddhists, and Jains, did not provide for adoption by other religious denominations. There are thousands of children in orphanages waiting to be adopted. Adoption is recognized as the best form for development of a child. Whilst giving the children adoption into citizens of other countries which have laws on adoption, made me reflect on the rights of the orphan children in India. The able assistance of lawyers and social activists whose research assisted me finding a way. Based on international conventions on the right of a child, ably marshaled, if I may so, by Colin, whom I hope is over here, and in view of our Constitutional Court, interpretation of these conventions ratified by India, that they could be read into Article 21, I held that the orphaned, destitute, abandoned, and similarly situated children have the fundamental right to a home, a family, and a nationality. The difficulty, however, was how could a judge, in the absence of legislation, grant relief to such children? Relying on the doctrine of parens patria, Article 225 and 226 of the Constitution of India, I held that a judge exercising the guardianship jurisdiction as parens patria could give such children in adoption. The fundamentals of this thesis possibly was flawed, but I remembered the words of Lord Denning. So there it is. In this book, I stood the law on its head on the hope that you may help to get it right way up. And the philosophy articulated by Krishna R.J. in his Tagore Law lectures. A copy of the judgment was sent to the Prime Minister's office, hoping that orphan children will see the light of the new millennium. The judgment was delivered in 1999, and in 2000, Parliament enacted the Care for Protection of Child Act 2000, providing for adoption of such children. Judicial activism helped in activating the legislative process. Several articles reflect the need for reconsideration of some judgments. Justice Subarao's dissents, which subsequently were accepted as the correct position in law, has made me to articulate for reconsideration of such judgments, include reservation for forward classes as upheld in Janhi Bayan, and the Stanislaus judgment on the rights of minorities to profess and propagate religion consequent to the judgment in Pusaswamy, accepting a citizen's right to practice a religion as an individual right flowing from Article 21 of the Constitution. Can I get it? Under the chapter of judicial creativity in several articles, I have examined the Constitutional Court creative role in advancing jurisprudence in the field of environment and human rights. The public trust doctrine is now explained in Kamala Nehru Trust has been debated in the context of the doctrine being applied for disposal of lands acquired by the government for specific purposes. The public trust doctrine investigates that citizens have rights to enjoy specific natural resources of which the government acts as a trustee and which resources cannot be alienated. The MC Mehta versus Kamalnath judgment first adopted the doctrine of trusteeship in Indian jurisprudence, which had been ably articulated by Professor Sachs. I have further articulated, based on the concept of intergeneration equity, which the Supreme Court has in Goa Foundation accepted, that while alienating public resources, a part of the profits generated on the basis of intergenerational equity have to be used for the benefit of citizens, and also pose the question that if individuals have no right in the natural resource, whether the public trust doctrine can apply in such cases of disposal of public property acquired for a specific public purpose. Women's right is the subject matter of one of the articles. In my judicial career, I had occasion to deal with the rights of women to carry on the profession of their choices. I refer to the judgment which is popularly known as the Bargall's judgment. I had the benefit of practically every senior counsel in the High Court of Bombay on either side articulating their views. The arguments were on every aspect of Part 3 of the Constitution. Most arguments advanced by the petitioners were rejected. Propositions based on Articles 14 and 19(1)(g) raised serious questions as to the applicability of those articles, as the state's response had raised some doubts in my mind. The persuasive discussion with my colleague, Justice Roshan Dalvi, on the bench, and further research helped me to find an answer to the doubts I had. I upheld the challenge of Article 14 19(1)(g) of the bar girls to dance as a part of the right to profession. The judgment was upheld by the Supreme Court. I remember, as it does not often happen, of receiving a bouquet of flowers at my residence sent by the then governor of Maharashtra. And present perhaps is also here is Colin, who had advanced a novel argument under Article 15, which I rejected, but which I find the Supreme Court has left open for consideration if and when perhaps it arises. On my first sitting in the Allahabad High Court, I found a long line of couples approaching the bench. I asked my colleague as to what was happening. These were married couples, and their marriages were either intercaste or interreligious. The lives of these couples depended on courts granting police protection. The judges of the Allahabad High Court had developed a jurisdiction for granting police protection to such couples. This innovation saved the lives and continued to save the lives of thousands of young people. Justice Kadju, as a judge of the Supreme Court, has laid down the law on this aspect. I pay my tributes to the judges of the Allahabad High Court, of which I was a part, in helping to save and continue to save young lives. Sitting in Bombay, hearing bail matters in an assignment, every day I came across applications for bail by mothers-in-law, sisters-in-law, husbands who had been charged of killing the daughters-in-law, wife. Most of the killings were gruesome. I can only describe these victims as the burning brides. And their only fault was that they could not bring in sufficient dowry. How inhuman can we be? However, I was attempting to work out some reliefs to create social awareness. However, the change of bench, it was not possible to articulate those concepts, and that has been one of my regrets in discharging my duties as a judge. No one speaks for these burning brides as if it's a part of everyday life. I have today the Chief Justice of India over here, Justice Vikranath, who one day will occupy that office, and other judges. You all entertain so many PIL petitions. I hope that somebody, sooner or later, takes up this issue. It's an obnoxious thing that is happening throughout a country. How can we be so inhuman to the fate of our daughters, to the fate of our sisters? Several articles reflect the rights of marginalized groups, SCs, STs, and OBCs. There's a specific article on the creamy layer. The learned Chief Justice has reflected on the views that I hold. After Nagaraj and Jarnail Singh excluding creamy layer from the benefits of reservation for SCs, STs is the law. The various challenges and amendments to Article 16 made on the ground of infringement of basic structure were rejected on the ground that Article 16 provided for protection on the basis of social and economic backwardness. In Davinder Singh, the issue was of subclassification, though the learned judges also gone the issue of creamy layer. Questions raised are to the application of the test of creamy layer for SCs and STs. OBCs, which can include castes, sections which have come out of social economic backwardness, no longer belong to their class, and as such can be excluded as held in Indira Sahani. SCs, STs, as articulated in Jarnail Singh, continue to be members of SC/ST as per the presidential notification. For the exclusion of members of SCs/STs who may have come out of social and economic backwardness, I have articulated that the capacity test, as explained by Justice Sawant in Indira Sahani judgment, should be the test that should be applied. This should be a basis on the basis or test on which the exclusion can take place and should be cadre and post-based. In delivering the Justice Vaidya Memorial Lecture in Sirsi, Karnataka, on the freedom of speech and expression, I have highlighted the importance of the need as to why freedom of speech and expression has to be protected by our constitutional courts. The right to free speech is the foundation for the exercise of other rights in Part 3 of the Constitution. However unpalatable they may be to ruling dispensations or groups opposed to the thoughts articulated. How can a society evolve if citizens are not allowed to articulate their views? Freedom of speech includes freedom of press, including commercial speech, as article of the Supreme Court. Justice Altamas Kabir, judge of the Supreme Court, later Chief Justice of India, had visited the High Court of Bombay, and my Chief Justice asked me to speak on the occasion. Justice Kabir was speaking as to the need perhaps to put some reasonable restrictions. Whilst replying, I reminded the learned judge of the wise words of Justice Vivian Bose, who, whilst releasing a Marxist leader, articulated that I know, even as I release you, that you will continue your activities. But my belief in the Constitution does not allow me to fetter my vision of the Constitution on your subsequent activities. If courts are restricting the exercise of free speech, who will test the court's guidelines. The duty of a constitutional court, therefore, should be to leave it to the legislature or executive and then test the law directions on the touchstone of Article 19. The hallmark of a judge must be to allow a broader view of free speech and expression. There are articles of PI jurisdiction and also on the contempt jurisdiction. I have argued that in India, there is still need for retaining the contempt jurisdiction, but as the late jurist Falin Nirman put it, use it wisely. How I share along with others who are present over here as to how can a default punishment be harsher than the principal punishment. I have tried to understand the jurisprudence basis of this thought process and I am unable to find that in any jurisdiction. I hope at some point of time our judges reflect on the same. Who else can speak but those of us who have been part of the system and feel the need for introspection? Throughout my life, I have identified myself in public life as not belonging to any religious denomination. My article on privacy and rights to minorities to profess, practice, and propagate religion, as investigated by Article 25 and now Article 21 in the Puthuswamy judgment, as an individual right, and the comments of Justice Serve in his book Constitutional Law of India, where he advocated for reconsideration of the judgment, have made me articulate my views that a Stanislaus judgment whose constitutional validity was upheld based on public order requires reconsideration. The Supreme Court has recently recognized that under these laws, stereotype complaints have been filed and innocent people have been targeted. Past economic liberalization, captains of industry, post-economic liberalization, captains of industry were articulating changes in the rights of labor as advocated in the Western Hemisphere without providing for social security those countries provided. As a judge of the High Court of Bombay, conversant with labor law, I had written an article which is reproduced in this volume and which was published by CLR. No society can contend that there should not be reforms, but reforms should be with a human face and a share in the stakes for the shareholders. In the prologue to this book, I have articulated the views reflected by so many, including me, on an individual right to bail. Article 21 must have some meaning to an under trial who, whilst incarcerated in jail, is not in a position to prepare his defense. Bail must be the rule, at least after investigations are completed, and not continued incarceration, unless in an individual case, bail ought to be rejected on known principles. The articles in this book cover a wide sweep of subjects on laws, justice, and constitution. I hope this will help, especially young lawyers, in reflecting on the path that they have taken as watchdogs of the Constitution to protect the integrity and uphold its values. And when someday you are called upon to occupy the seat of justice, you will protect and defend the Constitution and the rule of law. Last speech. I remember the words of learned hand, liberty lies in the hearts of women and men. If it dies there, no constitution, no court, no law can help it. I part with the hope that so many of you are present here and part of the legal fraternity, including those working in social fields, will help to keep the flames of liberty alive so democracy lives and every section of our people feel that they are part of this great nation, which breathed life on the midnight of 14-15 August 47. And I quote from the words of Pandit Nehru, "When the world sleeps, India awakes to life and freedom. The soul of a nation long suppressed finds utterance." I am thankful to the Chief Justice of India, for whom I understand this is the last public function as he moves to another chapter in his life. in the service of the people. To my colleague Justice Vikram Nath and to other colleagues sitting and retired judges of the Supreme Court, High Court, and senior advocates, social activists, and legal professions, all advocates and everyone present over here, that who have joined me in the reading of this book, a book thank you.
Thank you so much for those words, sir. I'd now request Honorable Chief Justice, Justice Gawai, to please release the book. Thank you so much, sir. Ladies and gentlemen, our next speaker is someone whose work has transformed not only legal thinking, but the lived experiences of countless communities. Norma Alvarez is a lawyer of the Bombay High Court, most closely associated with public interest litigation surrounding primarily environmental, wildlife, and women's issues. Advocate Alvarez began practicing public interest environmental law in Goa in 1988. By 2025, she had crossed more than 300 PILs, all argued pro bono. She was designated as a senior advocate of the bar in 2024. Advocate Alvarez is a member of the High Court Legal Services Committee, which ensures free legal aid to those in need of it. She also runs 2 animal welfare shelters. She was awarded the Padma Shri in 2002 for her animal welfare work, which including stopping the practice of bullfights and the extermination of stray dogs. A member of the Animal Welfare Board of India for 3 terms, she continues to be a member of the State Board for Wildlife and a trustee of the Goa SPCA. In 2003, she was awarded the Yashodhamini Puraskar by the government of Goa in recognition of her contribution to the cause of women. We are privileged to have with us today a pioneer, a leader, and a deeply inspiring figure in the legal fraternity. Ladies and gentlemen, please join me in welcoming Ms. Norma Alvarez, Senior Advocate, to say a few words.
Justice Bhushan Gawai, Honorable Chief Justice of India, Justice Vikram Nath, Justice Ferdinand Rebello, in whose honor we have collected and gathered here today, Senior Advocate Santosh Paul, my colleague from Goa, Advocate Akash Rebello, respected judges in the audience, advocates, friends, ladies and gentlemen. It is a pleasure to be here this evening with the release of Our Rights, a book that represents not just the distillation of years of legal thinking, but also a deeply personal reflection of a remarkable legal journey. I feel privileged to speak first about its author, Justice Ferdinand Rebello, who has been and continues to be an instigator. Yes, you heard the word right. He's always instigating me on new ideas to take to the courts, guide and mentor to me, especially in matters of environment law. It was Justice Rebello who argued the Goa Foundation's very first environment PIL in Goa way back in 1986, even before the Environment Protection Act came into force. The Goa Foundation had challenged the legal extraction of vast quantities of sand from Goa's beaches for industrial purpose. And thanks to Justice Rebello's erudite arguments, Justice Mota stopped the activity entirely. In fact, the sand dune case sparked environment litigation in Goa. Justice Rebello and I together argued a challenging case on the closure of traditional access to the beach, which ran through the premises of a five-star hotel. He appeared for the residents, I appeared for the environment NGO. We succeeded all the way to the Supreme Court, by which time, of course, Justice Rebello had been elevated to the bench. I remember arguing the first Environment Protection Act on coastal law before him in Goa, in the Goa High Court. His judgment laid out the foundations of environment protection, a clear, forward-looking, and deeply rooted in constitutional principles judgment. Today, with the release of our rights, I would like to take this opportunity to celebrate something many here may not know, and that is the deep contribution of Goa itself to the shaping of his legal mind. To understand Justice Rebello, one must first understand Goa. Its vibrant, noisy, resilient people, and its rich natural environment that spills out onto everyday life. Goa is a land where almost 60% remains under forest and tree cover, and we have over 700 square kilometers of wildlife sanctuaries in our tiny state. In Goa, people's affluence is measured not in money, but in the ability to live in one's ancestral home, grow one's own rice, and, most precious of all, to have time to talk, to reflect, or to simply stare. Justice Rebello is very much a product of that soil. His contributions to constitutional law, environmental jurisprudence, and everyday civic concerns, whether on open spaces, the monsoon fishing ban, the protection of hills and forests, coastal regulations, or the handling of garbage, all arise from that grounding. They also arise from his active participation in the political life of Goa. He served as a legislator from 1977 to 1980, and even after his elevation in 1996, he never abandoned his instinct to ensure a fair deal for workers and ordinary citizens. Our rights emerges from this rich journey. It reminds us that great legal minds come from every corner of India, and that legal imagination and constitutional insight are shaped by diverse regional experiences, each adding something original to the national conversation. Justice Rebello's rare combination of experience as legislator, lawyer, and judge gives this book a perspective that is truly unique. Justice Rebello has spoken about some of his articles, some of the reasons why he wrote some of them, some about his judgments. But let me give you a little insight into the book. The book straddles the vast terrain of law, from its moral roots to its contemporary challenges. It begins with deeply personal essays which explore the meaning of citizens' rights in everyday life. It then moves through history, revisiting the legal battles of the freedom movement, Gandhi's resistance to the Raj, and the paradoxes that shaped post-colonial India. Then we enter the realm of judicial creativity, with essays on the public trust doctrine, a favorite of Justice Rebello, judicial activism versus restraint, PILs, and benchmarks for reinterpreting the law to meet a changing society. The heart of the book lies in the section on the golden triangle of our Constitution, liberty, equality, and fraternity. Here, Justice Rebello examines reservation policies, caste discrimination, freedom of speech, privacy, religion, and the ever-evolving contours of the creamy layer debate. Subsequent chapters turn to social justice issues, the right to housing, women's access to justice, and human rights literacy. The section on criminal law raises hard questions about capital punishment, contempt, and the relevance of the IPC in a modern democracy. And the final section takes us to the global stage, from safeguarding future generations to the impact of globalization on labor rights. In its sweep, Our Rights shows us that law is not merely a set of statutes, but a living dialogue between history, morality, and modernity. And it reminds us that the pursuit of justice is a shared human endeavor. Permit me a small personal aside. Honorable Chief Justice Gavai once said, speaking to law students in Goa, that in his law college days, he was often found sitting on the compound wall rather than in the classroom. I can relate to that. I did not attend a single lecture during my 3 years law degree. I was raising a family at that time. I even wrote my third-year exams while heavily pregnant, unable to fit into those wooden benches. Perhaps the lesson in this is legal training cannot be confined to classroom notes. So if there is one book today that can help a law student, a young lawyer, or even a layperson make the leap from knowing the bare provisions of law to understanding the spirit of Indian law as it has evolved since 1947, it is Our Rights. Every essay stands alone, thoughtful, precise, and stripped of unnecessary scaffolding. Justice Rebello's writing is never verbose. It is bold, clear, and always, always anchored in the rights of the citizen, workers, women, tribals, nature, all of whom need the law's protection. So as we launch this book, we celebrate not just its author, but also the land and the people who shaped him. Justice Rebello's contribution to the evolution of Indian law reminds us that Goa produced in him a legal mind that I dare say could not have come from anywhere else. Thank you, Justice Rebello, for giving me this opportunity to speak. Though this is not an affidavit, I hope you will accept my words as a heartful tribute to you, a great judge who has always tried to do justice for all. Thank you.
Thank you so much, ma'am. Your reflections add such richness to this evening. Ladies and gentlemen, our next speaker is a deeply respected voice at the bar, Mr. Santosh Paul, Senior Advocate. Mr. Paul's legal journey is marked by his immense intellectual depth and commitment to law. He's practiced across a wide spectrum, from constitutional to criminal and civil litigation, bringing clarity and scholarship to fundamentally complex issues. His arguments are well known for their nuance, rigor, and thorough preparation. In recognition of his outstanding legal prowess, he was designated as a senior advocate by the Supreme Court of India in 2019. His combination of advocacy, scholarship, and commitment to strengthening democratic and judicial institutions makes him a vitally important speaker for us this evening. Ladies and gentlemen, please join me in welcoming Mr. Paul to say a few words.
Honorable Chief Justice B.R. Gavai, Justice Vikramnath, Justice Varale, the Chief Justice of the Delhi High Court, judges of the Supreme Court, High Courts, tribunals, and my dear friends. Justice Rebello has been a friend of mine for a long, long time, so it will not be a very unbiased opinion of the book or the man. I became his friend when I was a junior lawyer and he was already a judge. Now, I want to inform the younger audience, when we were lawyers, the younger set of lawyers, there was a big barrier between judges and the lawyers. We were not living in the age of Justice Gavai or Justice Vikramnath, who go out of their way to meet members of the bar, be amiable to them, make them feel comfortable. We were living in an age where there was a big wall of separation between lawyers and judges. And that is why we cherish this journey with Justice Rebello for almost 2.5 decades. And the fact that he has been friends with so many members of the bar and also his outstanding contribution is probably the reason we are seeing such a massive turnout for his book launch. The book, as I see it, is the reflection of the man and his work. Justice Rebello began as an idealistic lawyer, taught law at the Salgaonkar Law College, was incarcerated in a particularly dark chapter of our democracy at the Aguada State Prison. In 1977, he plunged into public life and was elected as a member of the Legislative Assembly, became a judge and then a Chief Justice of the Allahabad High Court. Which is why in the message which we find at the beginning of the book, and I cannot put it in better words, Justice Vikramnath says this book is recounting of a lived experience. Because Justice Rebello served on both sides of the institutional divide as a judge and as a legislator. There are very weighty topics which this book contains, but the fulcrum of the book is the ordinary people of India. So we have him dealing with adoption, we have him dealing with the rights of fishermen, which are affected adversely by mechanized trawling. We have the right of people to basic sustenance and basic nutrition for all those people living below the poverty line. There are problems of adoption. All these are dealt with great sensitivity, compassion, and humanity. That is the wonderful aspect of this book. Now, Justice Rebello is not discussing a constitution in the abstract form, but as a living document where something can be done for the ordinary citizens of this country. There is one particularly telling chapter in this book. There was a notification by the government that the orphans who have attained the age of 18 should leave the orphanage. Now, this is the most vulnerable section of the people, and we find how Justice Rebello gives life to the Constitution to protect the young and the weak who would be completely at a loss to come to terms with this world if they were let loose as contemplated in that government notification. There is two stanzas which stand out in this book, where Justice Rebello quotes Khalil Gibran, and which I think is the essence of his judicial philosophy, is the essence of his philosophy towards life. This is what is quoted from Khalil Gibran. Your children are not your children. They are the sons and daughters of life's longing for itself. The sum and substance, what the author is trying to tell us is our transient nature on this planet, and also our duty to make this world a better place in this short span of life which we have here. That is what he's trying to communicate throughout all these articles which are before us. I hope that there is a sequel to this book, and I also see a lot of judges here. We would also greatly benefit if they also author books, because we will understand them better. And as Justice Gawai puts it, any discussion will only ultimately strengthen the institution and the law. Before I part, I would like to inform something which many people will not know here. Whenever I am in Goa and I'm discussing with people, whether it is their social issues, their environmental problems, or the many problems which they face as belonging to that state, I find that invariably they have consulted Justice Rebello. So, lawyer, judge, legislator, chief justice, and now he is a wise sage of the tribe. And that journey is what is encapsulated in this wonderful book. I wish you all happy reading of this book. Thank you very much.
Thank you so much for that description, sir. Ladies and gentlemen, it is my privilege to now introduce a jurist of exceptional experience and modern vision, Honorable Justice Vikram Nath. Justice Nath hails from a family deeply rooted in law. In fact, he represents the fourth generation in his family to pursue a legal career. He studied law from the University of Lucknow in 1986. Shortly thereafter, in 1987, he enrolled as an advocate with the Bar Council of Uttar Pradesh and started practicing at the Allahabad High Court. For approximately 17 years, he practiced as a lawyer, building a reputation for a thoughtful and principled advocacy. His dedication and legal acumen led to his appointment as a judge of the Allahabad High Court in 2004, a role in which he served with distinction for many years. In September 2019, Justice Nath was elevated as the Chief Justice of the Gujarat High Court, a tenure marked by innovation and accessibility. Notably, he became the first Chief Justice of a High Court in India to live stream court proceedings on YouTube, bringing transparency and modern engagement into the functioning of the judiciary. In 2021, Justice Nath was elevated to the Supreme Court of India. He continues to serve with a deep commitment to justice, constitutionalism, and the fundamental values of our legal systems. His judgments and judicial decisions reflect a commitment to individual liberties, institutional accountability, and embracing change in the legal system. Justice Nath is frequently praised not just for his legal competence, but for his balanced temperament, foresight, and willingness to embrace technology and openness. He has also spoken with clarity about institutional integrity and the importance of adapting the judiciary to contemporary challenges. Ladies and gentlemen, let's welcome Justice Vikram Nath to say a few words.
A very warm good evening to everyone. Honorable Chief Justice of India, Justice B.R. Gawai, my esteemed colleagues, Chief Justice of Delhi High Court, on the dais, Justice Rebello, I should say my Chief Justice Rebello, Mr. Santosh Paul, Senior Advocate, and Ms. Norma Alvarez, Senior Advocate from Goa, former Chief Justices and judges, former judges of the Supreme Court also I see, senior advocates, young friends, ladies and gentlemen. This is the second book launch where I am the guest of honor. In the first book launch also, I was the guest of honor in Mumbai with Justice Gawai, who was the chief guest. There I had spoken an unscripted speech, and it was about 2 years back. But over a period of time, I have become sober and wise, so I have a scripted one today. It is a great honor to stand here as guest of honor to the launch of our rights. Essays on Law, Justice and the Constitution, written by Dr. Justice Ferdinand I. Rebello. There are some individuals who live one life in many chapters: legislator, lawyer, judge, scholar, arbitrator, mediator, and there are a rare few who live many lives in a single lifetime. Justice Rebello belongs unmistakably to that latter category. Justice Rebello holds a doctorate in law, and to the best of my knowledge is among the very few judges in India who can be addressed as Dr. Justice. Before donning the robe, he did something uncommon for most judges. He served as an elected legislator in Goa. Later, he practiced law with passion, often taking up social causes for the poor and voiceless. That early legislative experience, I believe, is not merely an item on a resume. It is a constitutional education in itself. Our Constituent Assembly, after all, was dominated by lawyers. Nearly 1/3 of its members were trained in law, and of those, several were active practitioners or legislators. It was this legal mind that drafted our Constitution, men and women who understood not only what the law ought to say, but also how it would be interpreted in the years to come. Being a legislator, therefore, does not just help the House, the legislature, it profoundly enriches the judiciary. For a judge to interpret a statute meaningfully, one must understand how a statute is conceived, debated, and born. The interpreter must know the intent behind the text, not merely the grammar of its clauses. Justice Rebello's legislative experience gave him that insight. When he later sat on the bench, he brought with him not just the precision of the lawyer, but also the purpose of the lawmaker. In 1996, he was elevated to the bench of the Bombay High Court and took oath on 26 June 2010 as Chief Justice of the Allahabad High Court, a tenure remembered for discipline, efficiency, and quiet dignity. And now, with this book, he adds one more title, author. The sociologist Emile Durkheim spoke of the shift from mechanical to organic solidarity, from societies held together by sameness to those held together by diversity and interdependence. Justice Rebello's life beautifully exemplifies this organic solidarity. He has been legislator, lawyer, judge, teacher, and now writer, each role distinct, yet harmoniously integrated into a single pursuit of justice. He reminds us that one can wear many hats without ever taking off one's principles. Those who have worked with him know another truth. Justice Rebello was an extraordinarily hardworking Chief Justice. I had the privilege of sharing bench with him in July 2011 after summer recess till he demitted office on 30th of July 2011. Hardworking might, in fact, be an understatement. Justice Rebello would not compromise on judicial work, despite the fact that Allahabad High Court, the largest in the country, had huge amount of administrative work. You could see him sitting in court at 10 a.m. sharp until 4 p.m. Punctually and commitment to work was something to learn from him. Immediately after rising from court, he would get busy with administrative work and other judicial work of dictation, correction, and signatures. He would never offer a cup of tea or coffee or even ask his bench partner to sit for a minute. Truly speaking, I initially felt bad in the initial few days sitting with him, but later realized his pitiable situation considering the quantum of work he had to finish every day. Wait. I'm coming to that. He would sit late in the evening, long after the last file had been signed. Many of his colleagues have confessed that under his watch, lunch often turned seamlessly into dinner, and yet somehow he didn't mind missing the meal. He loved his fried snacks, samosas and pakoras in particular, but one had to survive the workday to reach them. Till around 8:30 p.m., he was the strict senior, setting exacting standards for everyone. But after 8:30 p.m., the transformation was complete. The stern Chief Justice would become the warmest host. The court file would close, the conversation would open, and there would be always good humor, good company, and yes, good food and also better things. Justice Rebello's tenure as Chief Justice of the Allahabad High Court was marked not only by judicial excellence but also by outstanding administrative leadership. As primus inter pares, the first among equals, he never treated the office as one of privilege or comfort. Instead, he approached it as a responsibility that required him to reach out to every corner of the state. During his tenure, he personally traveled to the remotest districts of Uttar Pradesh, all 75 of them, to understand and address the concerns of the bar and the functioning of the subordinate judiciary. He believed that the Chief Justice must not remain confined within the four walls of the Chief Court. He made himself accessible to every member of the bar, patiently hearing grievances and resolving them wherever possible. Justice Rebello often said that he was not opposed to protest, but that protest must follow only after proper representation had failed. His message to the bar was clear. If there was a grievance, bring it to me first, because a simple meeting can often achieve more than a demonstration. His philosophy was grounded in a powerful sense of institutional integrity. He would often remark, if we as members of the bar and bench cannot resolve our own grievances among ourselves, on what moral ground do we issue a mandamus to the state or to the executive to set their house in order? It was, in every sense, the embodiment of the saying, one must set one's own house in order before setting the world right. That duality, rigor, and warmth is the hallmark of a well rounded judge and an even better human being. That same balance runs through his remarkable book, Our Rights. Reading it feels like walking through India's constitutional landscape, guided by a traveler who has lived every terrain himself. Justice Rebello reminds us that rights are not conferred by the Constitution, they are inherent in every human being. The Constitution merely recognizes and protects them. He calls Articles 14, 19, and 21 the Golden Triangle, equality, freedom, and life, the moral core of the Republic. He revisits A.K. Gopalan, Menaka Gandhi, A.D.M. Jabalpur, tracing how our understanding of liberty evolved from physical freedom to a life of dignity and purpose. He quotes Gandhi, whenever you do something, look into the eyes of the poor and see how it helps them. That sentiment runs through his writing. Law must not be an instrument of compassion, not just command. He recalls his own landmark judgment in the adoption case, holding that every abandoned child has a fundamental right to a family, a name, and a nationality. That decision did not merely interpret the law, it enlarged its heart. He speaks of women's rights, labor rights, environmental rights, the dignity of prisoners, all grounded in one simple belief that the law must serve life, not the other way around. At the same time, he cautions against judicial overreach. He recognizes that creativity is a virtue, but restraint is wisdom. As he writes, a judge's duty ends with the conscientious discharge of judgment, not with defending it in public. And perhaps most importantly, he calls for human rights literacy, a society where rights are not just taught in law schools but lived in daily life. Through all this, one hears not the voice of a retired Chief Justice, but of a lifelong student, as he humbly puts it. After serving as a judge, I remain a student of law. Those of us who know him beyond the bench know that the person behind these pages is the same person you meet outside, learned yet unpretentious, serious yet light-hearted, meticulous yet deeply humane. He can discuss Article 21 with scholarly precision in the afternoon and narrate an old Goan story over tea in the evening, usually with a samosa in hand. He embodies what I like to call constitutional grace, the ability to disagree firmly yet never discourteously. If I may take a small detour before concluding to speak about something that Justice Rebello's journey illustrates so well. In India, our judges retire at 62 in the High Courts and 65 in the Supreme Court. Across the ocean in the United States, judges of these federal courts hold office for life during good behavior. Now, whether lifetime tenure is a blessing or a burden is a separate debate, but what it does reveal is that judicial reflection need not end with retirement. In India, as long as the retirement age remains what it is, the mind must not retire when the robe does. Because every judge, by nature of the work, is already a writer, a thinker, a philosopher, someone who interprets human conduct through law and reason. Justice Rebello shows us what comes next: to turn from judge to jurist, from judgment writing to literature, from the bench to the classroom, because law, before becoming a tool for social justice, is an art of literature. As the film Dead Poets Society reminds us, medicine, law, business, engineering, these are noble pursuits and necessary to sustain life. But poetry, beauty, romance, love, these are what we stay alive for. And perhaps writing about justice, as Justice Rebello does here, is the poetry of law itself. As we celebrate this book, let us also reflect on its message. In our pursuit to protect our own rights, we must remain equally vigilant about the rights of our neighbors, our fellow citizens, and even those whose voices go unheard. Martin Luther King Jr. reminded us that injustice anywhere is a threat to justice everywhere. The framers of our Constitution foresaw this when they enshrined the word fraternity in the preamble. That word is not decorative. It is a moral command to build a classless, compassionate society bound by a duty to care to one another. In defending our own rights, we must not forget our duty to protect the rights of those being exploited, marginalized, or forgotten. Our rights find their truest meaning only when we safeguard the rights of others. And so, as we celebrate our rights, let us also remind ourselves of our responsibilities. And so, let me end with the lines of Henry Wadsworth Longfellow from The Builders. All are architects of fate, working in these walls of time, some with massive deeds and great, some with ornaments of rhyme. Each of us in our own way, whether through law, literature, or leadership, is building this republic. Thank you, ladies and gentlemen, and congratulations, Justice Rebello. May your pen stay as strong as your principles, and may the pakoras never run out. Thank you.
Thank you, Your Lordship. We are grateful for your generous words. Ladies and gentlemen, it is my distinct honor to introduce the Honorable Chief Justice of India, Justice B.R. Gavai. Justice Gavai is the 52nd Chief Justice of India, having taken oath in May 2025. Born in Amravati, Maharashtra, he embarked on a remarkable legal career that spans decades. He enrolled at the bar in 1985 and began his practice under the mentorship of late Raja S. Bhosle, a former Advocate General and Judge of the Bombay High Court. Justice Gavai has a rich experience as a practicing lawyer. Initially, he practiced independently at the Nagpur bench of the Bombay High Court and also served as assistant government pleader and additional public prosecutor. In 2003, he was elevated to the Bombay High Court and served in various benches at Mumbai, Nagpur, Aurangabad, and Panjim, gaining deep exposure across different legal fields. In 2019, he was elevated to the Supreme Court of India. Over the years, he has authored around 300 judgments, including several significant ones on constitutional law, administrative law, human rights, and public interest. Beyond adjudication, Justice Gawai has repeatedly emphasized the balance between directive principles and fundamental rights, a theme that echoes his constitutional philosophy and his belief in a just and equitable society. In all his work, whether on benches addressing criminal law, arbitration, environmental protection, or constitutional issues, he brings to the fore compassion, rigor, and a deep commitment to the rule of law. As Chief Justice, he is widely regarded as a jurist who combines deep legal knowledge with an empathetic understanding of the India's social realities. So we are truly privileged to have you with us today. We would request you to please say a few words.
My esteemed colleague, Justice Vikramnath, my esteemed colleagues, Justice Pankaj Mittal and Justice Prasanna Varade, the past brothers on the bench, Justice D.K. Upadhyay, the Chief Justice of Delhi High Court, the man of the day, Justice Rebello, Mrs. Rebello, Senior Advocate Norma Alvarez and Senior Advocate Santosh Paul, Akash, the large number of senior advocates present in the audience, and friends. I have written script as Justice Vikramnath had, but I don't propose to read it, because it will be again a repetition of what the earlier speakers have spoken to. In fact, I was expecting Justice Vikramnath to start with what he did at Bombay about Justice Bhosle. Justice Mittal and Justice Krishna Murari were present. I think Justice Varade was also there. So I thought that if he starts with an Allahabad experience, I was just remembering my days at Nagpur with Justice Rebello and Justice Dilip Sinha, and thereafter our sojourns at Aurangabad, Mumbai. Anyway, since Justice Vikramnath has restrained to do that, I will reserve it for some other occasion post 24th of November. My relationship with Justice Rebello dates back to 2003, when I was elevated as a judge of the Bombay High Court. Rather, I knew him prior to that, when after his elevation in 1996, he had come to Nagpur as a visiting judge and was sitting as a single judge. He became popular within a short period of time. I was the government pleader and the public prosecutor at Nagpur. Then we had invited him to the government pleader's office. He was kind enough to come. And his in-depth knowledge of law, his command over the court proceedings, impressed one and all, and particularly he became one of the most popular judges amongst the juniors like us. Shortly thereafter, in 2003, I was elevated, and again he came back to Nagpur as a senior judge. Thereafter, we had good time, as Justice Nath has pointed out about Allahabad. We had a good time at Nagpur. After some years, I shifted to Aurangabad. He came there as a senior judge, and We were together almost for a period of 3 months. And again, we spent a very good time. Thereafter, I shifted to Mumbai, and he was already a permanent judge at Mumbai. We had, I used to have had the pleasure of visiting his house. Now that house is no more there. A beautiful landscape building. It is now erased, and multi-story is coming there. And we used to spend evenings with him. Bhabiji had a very full store of fish and prawns in her. And we used to relish that, because I think he was one of the judges who used to go to Sassoon Dock once in a week to replenish his stock. Unfortunately, I could not get to sit with him for a long. When we were in Aurangabad, one of his partners went on leave, and for 4 days, I got an opportunity to sit with him. Though I had no opportunity to sit with him as a junior judge, I was always impressed with his vision of law, his judgments, and he was a role model for junior judges like us. His profound knowledge of law, his in-depth understanding of the problems of the common man, his ability to apply the Constitution and the laws to find out real justice to the citizens of this country are really very rare. And as I said at my felicitation in Panji a couple of months back, that he was truly a person who deserved to come to the Supreme Court. However, by not going to the Supreme Court, he did not lose anything. It was the Supreme Court and the Indian judiciary who missed him. I think by not coming here for those 3 years, he has built up large reserves, and immediately after retirement, when he started arbitration, he received a distinction of being the most sought after arbitrator, and people used to wait for his calendar so that they could accommodate their matters before him. It's a great honor and privilege for me to release his work on our rights, essays on law, justice and constitution. As Justice Vikramnath just now said, that even after retirement, the judges are active, and now Justice Rebello, after spending more than a decade on building the resource in arbitration, is now devoted his time to give back to the society what he has experienced in more than half a century of his journey as a lawyer and as a judge. The book is a rich collection of vivid experiences that he had as a lawyer, as his brief stint in the legislature, an activist, a professor of law, and a judge. His book starts with a chapter about the rights of the adopted children. I'm really happy that when he mentioned in the beginning that his judgment on adoption, he had sent a copy of the judgment in 1999 to the Prime Minister, and within 2 years, it saw an enactment being enacted on the basis of the said judgment. And therefore, what a judicial activism can lead to is his judgment on adoption of his judgment on the rights of the adopted children is really a remarkable piece. He has written on a variety of topics. I have just now referred to the judicial activism. But at the same time, like I share it with you, that judicial activism is bound to remain in the country wherever the legislature or the executive, they fail to safeguard the rights of the citizens. The constitutional courts of the country, be the high courts or the Supreme Court, are required to step in. But at the same time, the judicial activism should not turn into judicial adventurism or judicial terrorism. A limit within which the judges should resort to judicial activism, I think he has very vividly explained. He has also addressed elaborately on the development of the fundamental rights post Maneka Gandhi. In Maneka Gandhi, the decision was restricted to the travel of the petitioner therein to the country outside India. However, for the first time, the Supreme Court held that the fundamental rights are not only those rights which are enumerated in Part 3, but anything evolving from the trinity of Article 14, Article 19 and 21 would constitute a fundamental right. And his work on explaining and the fundamental rights which have been delineated by judicial interpretation would be really a masterpiece for the students of law. He has also addressed about how the law and the constitution have paved a way for a country like India, which is a country of diversity, to be united. As Dr. Ambedkar in his speech on 4th of November 1948, when he was criticized that the constitution is too much tilted towards a unitary state, and on the other hand is being too much federalistic, had answered that criticism that our constitution is neither fully federal, neither fully unitary. It's a mix of both the systems. But one thing that I can assure you is that we are giving a constitution to the country which will keep the country united and strong in the times of peace and war. And we find that what he had said 75 years back has truly lived up to the day. He has also spoken about the human rights, the subject which is very close to his heart. And he said that human rights cannot be restricted. I would like to quote from him his chapter on human rights, and I quote, "Understanding and amplifying the concepts of human rights cannot be the exclusive domain of lawyers and judges. Human rights can best be protected and the rights enjoyed when the meaning of human rights is spread to all the sections of society. Rights of all sections of society are involved in the process, given that such rights required balancing of competing and conflicting interests of the values." His emphasis on competing and conflicting interests reflect his nuanced understanding of rights jurisprudence. Rights, as he looks at them, are not abstract ideals, but the living guarantees that must be negotiated in the context of real social tensions. Justice Rebello does not feel shy of addressing the contemporary challenges the judiciary is facing today. And he observes that with very frankness and straightness, and I quote, "We must painfully admit that the legal system now suffers from several ills. The foremost among them are the long delays, docket explosion, mounting arrears and great expense. These ills are having a very deleterious effect on the administration of justice. Unless early corrective action is taken, the credibility of the very system will be at a stake. The judiciary derives its power and prestige solely from the public confidence it enjoys. The same very much depends on its independence, impartiality, and integrity. It should be the concern of all judges as well as lawyers, to see that this foundation on which credibility of the judicial system rests is not eroded. I unquote. These words capture not only his diagnostic clarity, but also his commitment to the institutional honesty and integrity. Justice Rebello has also elaborately written on the affirmative action, the jurisprudence evolving the affirmative action in the country, right from the cases of Balaji and Devdasan up to the last judgment on the issue, to which Justice Vikram Nath, me and Justice Pankaj Mittal are a party. As a matter of fact, when he spoke about this book to me about a couple of months back, he has a distinct style of calling me. He begins with "Arey Bhushan." So I received a call from him. Yes, sir. He said, "Arey Bhushan, वो मैं किताब लिख रहा हूँ, सब उसमें मेरे जो स्पीचेज और इससे है उसका कंपाइलेशन है, और तेरा वो अभी वो क्रीमी लेयर का जजमेंट है उसके बारे में भी मैं लिख रहा हूँ." And he said कि I am agreeing with your view on subclassification, but I am criticizing your view on the concept of creamy layer for scheduled caste. I said to him, "Sir, you are most welcome. I believe in a dialogue. As a Chief Justice, I have been presided 3 Constitution Bench judgments. 1 judgment is delivered and 2 will be delivered within a couple of days. But I don't believe in first writing the judgments and giving it to the colleagues for their comments. Immediately after the Constitution benches were over, all of us sat together, discussed, and wherever there were some creases to be ironed out, we sat again and sought to iron out the creases. And therefore, it is a dialogue, it is an interaction which develops the law. As we see that many of the dissents of 70s have now become the judgments of majority. But I have never I completed 22 years of judgeship on the 14th of this month, and within a week will be on the other side of the bench. I have never persuaded any of my colleagues to accept my view. We have deliberated at times, Justice Vikram Nath would agree with that. We had a disagreement over one matter, and that disagreement went on for at least 2 or 3 months. Incidentally, for 2 weeks he had gone abroad to meet his son and daughter-in-law. I thought that matter would come up before me. But then I was not the Chief Justice, so I did not have that power. Unfortunately or fortunately, that matter did not come. And after that matter was listed, after he came, and then when it was called out, I said, "I am not speaking anything. You decide what is to be done." He was kind enough to agree with me. And therefore, I am of the view that a judge should never be too sticky to his view. A judge should not feel that once he has decided in a particular way, he is right and there can't be correction. As a judge of the High Court, I have held my at least 2 judgments, reported judgments, to be per incuriam. Because to err is a human, and you can only correct yourself, if you are open to the criticism or open to seeing the other side of the matter. Justice Rebello and Mrs. Rebello, apart from Justice Rebello, a great a great jurist, and Mrs. Rebello, a great companion to him, a great host, are also great human beings. I have personally had a relationship with him spanning for more than 22 years. And in my last 6 years as a judge of the Supreme Court, 6.5 years, I have been to Allahabad, within the jurisdiction of Allahabad High Court, to various places in the Uttar Pradesh. And wherever I went, the judicial officers, after coming to know that I also belong to Bombay High Court, they always used to say that they used to always praise Justice Rebello and Mrs. Rebello as one of the best Chief Justices they had. In fact, in the recent past, we have given 3 Chief Justices to Allahabad High Court. 2 of them are fondly remembered by the judges as well as the trial judges of the UP judiciary. This book, the great work of Justice Rebello, is handed over to us when we have completed the journey of 75 years of our Constitution, and will be completing the Amrut Mahotsav of our Constitution on 26th of January 2025. As I always say that one should always be pragmatic. And I say that in the last 75 years, the legislature, the parliament, the executive, and the judiciary have always worked in a pragmatic manner. Our Constitution is wedded to the ideas of justice, social, economic, and political, which values are also close to the heart of Justice Rebello. Post 1973, after the Keshavanand Bharati case, the equitable balance of fundamental rights and directive principles and burying of the past dispute between fundamental rights and directive principles have paved the way of the Indian Constitution journey towards the social and economic justice. As Dr. Ambedkar said in his speech on 25th of November 1949, that political justice is of no use unless the social and economic justice underlies beneath it. All the institutions of the Constitution, all the wings of the Constitution, the executive, the judiciary, and the parliament are bound to take further the goal of political, social, and economic justice. The insightful work of Justice Rebello, he has observed about, even after the 75 years of Constitution, still the gender inequality exists. Still we have a caste system in some states. Even after 75 years of the Constitution, the caste discrimination in some area still exists. I am sure that this book, which will be a treasure for judges, lawyers, and students of law like me, and will act as a guiding role in helping all of us to pave to walk towards our journey of social and economic equality along the political justice. I congratulate Justice Rebello on this occasion for getting this momentous work to us. I am sure that he has many years to contribute to the society. I wish him and Madam Rebello and his family a very healthy, happy life and continued contribution to the society in future. Thank you for giving me this opportunity.
Thank you, Your Lordship, for your inspiring address. Your presence has truly made this evening very special. May I now request Mr. Uday Nayak to deliver the vote of thanks.
Good evening, distinguished guests. As our wonderful program draws to a close, it is my distinct privilege and honor to deliver the vote of thanks on this memorable occasion. First and foremost, our profound gratitude goes out to the luminaries who have graced us with their presence and their insightful addresses. We are deeply indebted to our chief guest, the Honorable Mr. Justice B.R. Gavi, Chief Justice of India. Sir, your presence is an immense honor, and your foreword to the book reflects your profound appreciation of Justice Rebello's intellectual and judicial legacy. Your address was truly enlightening. Thank you, sir, for your gracious presence. A sincere thank you to our guest of honor, the Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India. Sir, your message in the book highlights Justice Rebello's unique vantage point drawn from his experience both as a legislator and a judge. We are grateful for your time and your enlightening address. Thank you, sir. We would also like to express our gratitude to the distinguished justices present here today, including Justice Pankaj Mittal, Justice P.B. Varale, Justice Manoj Mishra, Justice A.S. Chandurkar, he has left a little early, Chief Justice of High Court of Delhi, Justice D.K. Upadhyay, sitting judges of the High Courts, chairpersons and members of various tribunals, and other retired judges of the Supreme Court and High Court. Thank you for your gracious presence. My thanks also extend to the eminent speakers, to Advocate Akash Rebello. Thank you for the warm and gracious welcome address. To Senior Advocate Norma Alvarez and Senior Advocate Santosh Paul, thank you for sharing your valuable perspective on the book. Thank you. I must also acknowledge the other contributors to the success of this evening. Advocate Nandita Bajpai, thank you for your expertly comparing the program. To the publishers, All India Reporters, Private Limited Nagpur, thank you for bringing this important book to the public. We extend our gratitude to Mr. Aditya Vaidya, Dr. Rohini Mahorkar, and a team of All India Reporter. Thank you to Mrs. Delphine Rebello for the beautiful recitation of Where the Mind is Without Fear by Nobel laureate Rabindranath Tagore, which set a thoughtful tone for the evening. A special thanks to Santosh Paul and his team, along with Advocate Triveni Putekar, for all their help in organizing this event. Special thanks to media and press for covering this event. Finally, my heartfelt thanks to all the invitees and guests, including social activists, professors of law, and all who have taken the time out of their busy schedules to celebrate the release of the book, Our Right, at the India International Center. This event, held here in New Delhi, has brought
together a remarkable assembly of legal minds. I want to offer a special note of appreciation to the many legal luminaries and friends who have traveled from various regions, including Goa, Maharashtra, and various other parts of India. Your presence is powerful testament to the deep respect, professional admiration, and sincere affection for Dr. Justice Ferdinand Inacio Rebello. This collective love for his work and his commitment to justice is what truly makes this evening special. I still remember Justice Rebello once sharing his wish to do something meaningful for society after his retirement, something that would give true purpose to his life and existence. This book, which beautifully carries forward the Republic's continuing dialogue with its founding promises, is a part of that very contribution. Sir, with our rights, you have not only taken a step in fulfilling that very aspiration with remarkable grace and depth, but you have also created a work that will continue to inspire and positively influence countless individuals in the years to come. Thank you for sharing your heartfelt reflections on vital themes such as reservation policy, human right literacy, and enduring need for law to walk hand in hand with justice. Your words remind us that the pursuit of justice is, above all, a pursuit of humanity. Ladies and gentlemen, we began the evening with tea and coffee, and we now look forward to continuing our fellowship over cocktails and dinner. Thank you all once again for making this book launch a truly memorable and meaningful occasion. I now request everyone to kindly rise for the national anthem. Thank you.